Good morning, everybody. We'll be starting in just a minute. Just let everybody file into the virtual room. Get your seats, get a drink of water, settle in for the next hour and a half. Thank you for being here with us.
Good morning, good morning.
All right, it's 9 o'clock straight up, so let's get this party started. Hi, everybody. My name is Tara Brennan, and I'm the events manager here at CEA. Welcome to the 2021 Labor Law Update webinar that's sponsored by the Monterey County Workforce Development Board. Before we start today's webinar, I just need to go over a couple of details with you. Your audio is muted, so you will be able to hear us, but we won't be able to hear you. If you have questions pertaining to the presentation, please type those in the Q&A box. That's where the presenters will be able to monitor your questions and be able to answer them as we go. If you have any technical difficulties, or if for whatever reason you did not receive the participant handouts that were sent with this link, please put your information in the chat box and I will be monitoring that. So anything pertaining to the presentation goes in the Q&A box, and anything technical, or if you need handouts, put that in the chat box. There is going to be a quick 30-second survey at the end of this webinar. So please just take that time to fill that out for us. It really helps us out, and it potentially could get you a Starbucks card because there will be a raffle. Introduce Kristen Arps. She is from the Monterey County Workforce Development Board, and she's going to kick it off for us. Kristen?
Thank you, Tara. Good morning, everyone. I just want to take a moment to welcome you all on behalf of the Monterey County Workforce Development Board, and to thank the California Employers Association for providing this important webinar. This year, the Workforce Development Board has entered into a partnership with the CEA in order to provide free training and technical support to Monterey County businesses. This is the first of many webinars to come out of our collaboration, and we hope you'll take advantage of all of these opportunities and resources from CEA, particularly during this tumultuous time. I know it's really challenging for all of you, for all of us. We also hope you let us at the Workforce Development Board know if there are additional ways we can support you and your businesses. I'm now going to pass it over to our Business Services Manager, Jerry Hernandez, who will provide a brief overview of the services available to you as Monterey County businesses. Thanks again for joining us.
Thank you, Kristen. What I'd like to do, first of all, is welcome you all here. As Kristen mentioned, these are difficult times, and frankly, as an employer, your primary responsibility right now is retaining your business. So business retention really is something we're interested in helping you with. We want to work with you to help you stabilize, strengthen, and grow your business. And so we have services that fall into three categories: recruitment, training, and other services. Under recruitment, we have services such as job and career fairs. And with COVID now, we have a platform that allows us to have virtual job fairs. We also have customized employer recruitment events, as well as job boards and promotional activities. The job boards is a way of us posting job opportunities that you want prospective job seekers to know about. We have access to both the Cal Jobs format as well as our Monterey County Business website, and we have there a job board. Under training, there are some services that we've worked with employers over the years. One, we have grants available under the Incumbent Worker Training Program. So if you have existing employees, I should say, that you want to elevate and provide them with upskills training, the Incumbent Worker Training Program would be something you'd want to learn more about. On the job training program also is available for entry-level workers. Individuals there could get 50% of their training reimbursed to you as the employer. And then we have layoff aversion. We see that at times it's necessary to lay off your staff. We have services that would allow that process to be more, would be a softer landing for your existing employees. We'd be allowing them to learn about what EDD benefits they have, what reemployment opportunities that exist, and that's where we come in. Other services that we offer are small business grants. We're now in the third round. We'll be going into a third round of a grant program that makes available up to $10,000 to businesses that have been impacted by COVID-19. We're going to be learning more about a new service that we have with CEA, the Human Resources or HR Hotline. Then we have resource and referrals opportunities that we can send you to other technical assistance providers that can help you with your small business. And so these and other services are available. And we just want to make sure that you're aware of the services that we offer for you at no cost. And the way you can contact us, here you have our contact information, the next slide, and you'll be able to see how you can contact us. You can reach me at my phone number, 755-5393. Again, area code 831-755-5393. My email address, as well as our website address, are also included on the slides. So again, I want to thank you. We are here to help you, and we want to make sure that you succeed. Now I'd like to turn it back to Tara.
Great, Terry, much. So now I would like to introduce our presenters. We have Jessica Hawthorne and Astrid Servin. Jessica is our Senior Vice President of Human Resources and Operations, and Astrid is one of our HR directors. So ladies, I will let you take it from there. Oh, just really quick, one more thing. It does look like this webinar is being recorded and it will be available to you. So if you have any questions about that, you can reach out to the Workforce Development Board. Thanks.
Thank you, Terry and Kristen and Jerry. California Employers Association is always thrilled to partner with workforce development boards. The work that your workforce development boards do is all encompassing, and you can't even put a dollar amount on the value of the resources that they provide you. So in addition, we get to partner with Monterey County Workforce Development Board and provide you with the Human Resource Hotline. This is your number for any business in the County of Monterey to use if you have a human resource question. You've got to fire somebody. You forgot what the minimum wage was. Employees aren't getting along. California keeps passing crazy laws and we don't know what to do. Call us. Our job is to give you peace of mind so you don't have to worry about that stuff. We live this stuff day in and day out, and we are happy to do it and happy to support all of Monterey County employers. We probably get about 2,000 calls a month. And so we spend a lot of time talking about this stuff. We are open Monday to Friday, 8 to 5. We will save you time and money because there's so much information out there on all these different things. We'll help just pare it down. Just yesterday, we did a free webinar on the supplemental paid sick leave in California. And on our website, we are employers.org, and under HR Answers, we have a COVID-19 resources page. And all of those resources are accessible by you as a hotline member. Sample COVID-19 plans, sample supplemental paid sick leave policies, pretty much anything you need right now to kind of get over this COVID hump. I don't even know if you'd call it a hump anymore. It's a bit of a plateau, it feels like, but we are here for you, Monterey County. And thank you so much for the Workforce Development Board for partnering with us so we can help support Monterey County employers. And please spread the word to all of your colleagues out in the field, because the more calls we get, the happier we are. So please give us a call at that 888-217-6899. It's free. Your Workforce Development Board has provided that resource for you. All right. So this is CEA. We are CEA. As I said, our goal is to provide employers with peace of mind. We do human resource compliance solutions, training and development, recruiting services, anything in the HR life cycle. In the olden days, we would go on site into somebody's business and do HR checkups and harassment prevention trainings and those sort of things. Now we use a lot of Zoom, but we are going on site again. We've got nice, fancy, clear masks. We're ready to roll. We've got hand sanitizer on our belt. So if you need additional support beyond just the hotline, obviously, please reach out to us, but the hotline is an amazing resource. Our team of 7 is here to support you. We cannot give you legal advice, however, so please don't take anything that Astrid or I say today as legal advice. If something is of legal significance to your organization, make sure you get legal counsel to support you through that process. All right, so what are we talking about today? So this is our labor law update, which obviously we do annually. And I was mentioning to Kristen and Jerry at the beginning, we've probably updated this at least once a week since January, because it's just been prolific on the federal and state level. But we're going to do some high level stuff for you. We'll get in the weeds a little bit, but if you have questions as we go through the presentation today, please use that Q&A box. It looks like 2 little dialogue boxes talking to each other. And Astrid and I will both monitor that Q&A box for you so we can try to answer your questions as we go along. And if we don't get to your questions, you can call us on that HR hotline. So we're going to go over the California Family Rights Act amendments, some other leaves of absence issues. AB 5, that independent contractor law, has received some clarifications that made it even more clear as mud. A lot of minimum wage and exempt salary increases, COVID-19 issues. Of course, we can't have a presentation these days without that. There's vaccinations issues, supplemental paid sick leave. There's also pay data reporting. So if you're one of those larger employers with 100 or more employees who usually does EEO-1 reporting, you now have pay data reporting for the California Department of Fair Employment and Housing, and that is due tomorrow. So hopefully this is not the first you've heard of it. And then there's a few other additions at the end just for our own edification and to round out the presentation. Okay. We're going to jump right into leaves of absence and benefit changes for 2021. So in California, we have what's called the California Family Rights Act. Now, the California Family Rights Act is sort of the companion law to the Federal Family Medical Leave Act. So a lot of people have heard of FMLA, and that applies to employers with 50 or more employees. A lot of employers don't know that there's also the CFRA, that California Family Rights Act. The CFRA, up until January 1 of this year, applied to employers with 50 or more employees, just as the federal law did. As of January 1, the California Family Rights Act, or CFRA, like we like to call it. Some people like CFRA. I prefer CFRA. You be you, everybody. But CFRA now covers employers with 5 or more employees. So that's a big leap down. So if you have 5 or more employees anywhere in the world, you are now covered by CFRA. CFRA was also amended as far as expanding the number of covered reasons that people can take CFRA. And if you had 20 to 49 employees, there was that new parent leave law for the past couple of years. Well, that's been removed. That's gone. So if you were in that 20 to 49 employees range and you had a new parent leave law policy, you're going to want to get rid of that because that no longer exists. But you are going to fall under CFRA because you have 5 or more employees. So here are some of the changes from CFRA before 2021. So expanded coverage, it used to be 50 employees. Now, if you have 5 or more employees anywhere, doesn't matter if they're California, Texas, or Mars, if you have 5 or more employees on your payroll, you are going to be covered by this law. What covered by this law means is that you must have a CFRA policy and you must have this CFRA poster hanging in your workplace. Another big change is in order for an employee to be eligible to take leave under this law, they have to work for you for 12 months, 1,250 hours in the previous 12 months, and prior to this year, work at a location with the specific number of employees within a 75-mile radius. Now there's no 75-mile radius requirement. So if you have 5 employees and they're all over the country and you have 1 California employee, that employee will be eligible for time off under CFRA if they've worked for you for a year and 1,250 hours in the previous 12 months. So what can they take leave for? Eligible employees, those folks who've been there for a year, 1,250 hours, can take time off, and that's 12 weeks of job protected leave and continuation of their health benefits as though they're working, if to care for themselves, but also children of their registered domestic partner, to care for their grandparents, their grandchildren, their siblings, their children, parents, their spouse, their registered domestic partner, and any child. It doesn't matter how old your child is, if you need time off to care for them, you can take protected time off under CFRA now. Prior to January 1 of this year, there used to be an exception to guaranteed reinstatement, meaning we didn't have to protect your job if you were a key employee. And these are your top 10% earners in your organization. That no longer applies under CFRA. So everybody gets reinstated. It used to be also, you could take CFRA for baby bonding, but if you and the other parent worked for the same employer, you had to split that time. So it was 12 weeks and both parents had to decide how much each one got for a total of 12. Now, each parent, if they work for the same employer, gets a total of 12 weeks for baby bonding with the new child, whether it's birth, adoption, or foster care. As I mentioned before, the new parent leave law covering employers with 20 to 49 employees has been repealed. So if you fit into that, that's going to go away because CFRA is going to take over for that. The big thing with CFRA, just like the federal FMLA, is there are mandatory forms, notices of rights, designation notices that you must use when somebody's eligible for these leaves. So pay attention to that and make sure you're aware of what those are. So here's a nice chart. If you're a more visual person, the differences between CFRA 2020 and before, and now what we must comply with as far as CFRA. So as a covered employer, it's just 5 employees anywhere in the universe. An employee is eligible to take that leave if they've worked for you for 12 months and 1,250 hours in the previous 12 months. The reasons for the leave are the same as before with many additions. So almost any close family member, somebody's going to be eligible to take that time off to care for that family member. Reinstatement rights are guaranteed. The only time reinstatement rights are not guaranteed is if that position would have been eliminated regardless of the leave, a layoff or something along those lines. The other big difference is parents don't have to share that 12 weeks if they're working for the same employer. Each parent gets 12 total weeks. Okay, so we talked about covered employer, 5 employees anywhere in the universe. Employees are going to be eligible for 12 weeks of unpaid time off, continuation of health benefits if they were getting health benefits prior to the leave. So they're going to be eligible if they work for you for a total of 12 months. And total of 12 months means they could have worked for you 1 month every year for 12 years. That's 12 months. However, they may not be eligible if they hadn't worked 1,250 hours in the previous 12 months. So both of those things need to be true in order for the person to be eligible for that leave. And we've gone through those covered reasons. There's a number of covered reasons. And in addition, there is now a qualifying exigency reason under CFRA, which pretty much mirrors what was eligible under FMLA, under the federal law. And that's taking time off for emergency, meaning somebody in my family is going off to service in the military and I need to deal with legal issues and so forth. And so those are all up to 12 job protected weeks unpaid. So on the pay issue, just for clarification, you as the employer do not have to pay the employee. The employee may opt to use maybe paid sick leave or vacation or PTO. But when somebody goes on this leave, you give them a state disability insurance pamphlet or a paid family leave pamphlet, and they can apply to the state for those benefits because they've already been paying into that through payroll taxes. So you as the employer are not compensating the employee during this leave. So here's a leave calculation example for you. If you're a smaller employer, you've got 10 employees. Pregnancy is where it gets most complicated in California because CFRA does not consider pregnancy a disability, whereas the federal FMLA does. However, in California, we have the Pregnancy Disability Leave Act, which considers pregnancy a disability. So pregnancy disability and FMLA typically run together if the employee is eligible for both. So let's talk about this leave calculation example. You've got a full-time employee, you've got 10 employees total. This full-time employee's doctor has ordered them to take time off for pregnancy, and it ordered them to take a full 4 months, because pregnancy disability leave, it's a maximum of 4 months or 17 1/3 weeks. So this employee takes 4 months of pregnancy disability leave, which also provides job protection, continuation of health benefits. Since you only have 10 employees, FMLA is not going to come into the calculation here, because in order to be a covered employer under FMLA, you must have 50 employees. So we're just talking about California's pregnancy disability leave, maximum of 4 months based on what the doctor orders. Once the period of disability expires and the baby is here, the employee is going to be eligible for up to 12 weeks of job protected time off for baby bonding. So this employee, based on how much time the doctor considers her disabled, in addition to the 12 weeks of CFRA, could take about 30 weeks of unpaid job protected leave with continuation of health benefits. So that's going to be a big pivot for a lot of employers, especially in that 5 to 25 range. If you're those larger employers who've been following FMLA for all this time, it's not going to be markedly different. But here's another example. You have more than 50 employees. You've got a full-time employee who's been employed for over a year, and they need time to take off for a sick grandparent. So I mentioned earlier, FMLA and CFRA do not run at the same time for pregnancy, but for pretty much everything else they do. Here's the rub, California. California Family Rights Act now covers family members that FMLA doesn't, grandparents being one of them. So this employee may not be eligible for FMLA because FMLA doesn't cover time off to care for a grandparent. However, CFRA does. So the employee will get 12 weeks of unpaid job protected leave, continuation of benefits to care for their grandparent. They come back to work and they experience their own serious health condition. Likely they're going to be eligible for additional 12 weeks under FMLA because they haven't exhausted their FMLA yet. So there's a potential of 24 total weeks of time off that employee will have. Here's another example, and this is the PDL example, the pregnancy example. You've got a full-time employee, you have 75 employees total. So you're covered by FMLA, the employee is going to be eligible. The doctor orders the full time off for pregnancy disability. PDL and FMLA are going to run at the same time. So overlapping completely. CFRA is going to sit over here until we're ready for baby bonding. Even though FMLA is only 12 weeks and PDL is 17 1/3 weeks, that's okay. They're still running at the same time. They're going to exhaust the FMLA, and then their PDL is going to be ended when the baby's born, or if the person continues to be disabled, they can take CFRA for up to 12 weeks at that time. The reason why that's important is that you designate that time off as FMLA. So if the employee then comes back again with maybe a different health issue or to care for a family member, there's not going to be that time off available for them. So here's that open question that we're getting at there with that middle example is there's CFRA only leaves. The eligibility to care for certain family members is covered under CFRA, but not FMLA. We don't know how the law is going to reconcile that. We're waiting for the Department of Fair Employment and Housing to give us additional guidance on how to deal with the overlap or the disconnect, which is probably the better word, right? So we are recommending always err on the side of caution. We always do what's best for the employee if we don't know the answer because the law didn't give us that answer. So err on the side of caution or talk to your legal counsel about what sort of flexibility you may have or may need to take because we don't really know the answer of how that overlap is going to work out yet. Okay, so this is good news in light of all of that we just threw at you with this new compliance with CFRA. Is that the Department of Fair Employment and Housing has a mediation pilot program to deal with disputes in relation to family leave issues. So compliance with CFRA. If you have 6 employees, complying with CFRA is a whole new land for you. That's a big change. There may be missteps. Maybe you forget to provide a certain form. Maybe your policy isn't as clear as it should be. This is actually very good news for employers because it gives you an opportunity. If an employee complains about maybe interference with their rights under CFRA, you can go into this mediation and say, we're still new to this. We're trying to figure this out. Let's make sure we want to do it right, but help us through this. So this will keep it from turning into an actual legal dispute and mediate it and resolve it on the lowest level. So this is going to sunset in 2024. So it gives smaller employers enough time to get in compliance and kind of learn how to navigate this road. Okay, in conjunction with CFRA or even FEMLA, when an employee takes time off to bond with a child or to care for another family member, as I mentioned before, FEMLA, CFRA, PDL, these are all unpaid leaves. So if I'm taking time off under FEMLA, CFRA, how am I going to get paid? I mean, if I'm taking a total of 30 weeks, I don't think anybody has 30 weeks of vacation or paid sick leave. So what the state of California has had in place for quite some time, I think since 2006, is this paid family leave program. And it's administered the same way the state disability insurance is administered. It's through payroll taxes. It's already taken out of your check. And it's an insurance program that the Employment Development Department administers. So you take time off under CFRA to bond with your child, to care for a family member. You can get up to 8 weeks of wage replacement through the paid family leave program. It used to be 6 weeks, but in July of last year, it was up to 8 weeks. And it's about 70% of your current salary at this point. So it's a pretty hefty benefit. And sometimes it helps extend your vacation or paid sick leave because you can supplement the 30% with any accrued time you may have. But again, this is just insurance through the state that people have paid into. This doesn't provide job protection. It's just money. There is a new pamphlet and a new poster for this year, for 2021, because of these changes. So make sure you're giving out the paid family leave pamphlet upon hire and when somebody's eligible for leave of absence, so they can go to the state and apply for that money. And make sure you have a 2021 poster that's up to date. Okay, another leave or a job protection in California is for crime victims. So in California, all employers are prohibited from discharging, discriminating, retaliating against an employee who's a victim of a crime or abuse if they need time off to deal with court orders or court proceedings. Prior to 2021, this protection was limited to people getting legal support for domestic violence, abuse, or stalking. For 2021, it's been expanded to any crime victim. You cannot retaliate or take adverse action against somebody who takes time off to deal with the legal aspect in response to a crime that they've been a victim of. If you have 25 or more employees, however, you also have to allow employee of a victim of crime or abuse time off for medical reasons. For 2021, this has been expanded to any victim of crime or abuse and including beyond just medical for injuries, psychological mental health services, as well as safety planning. So make sure your policies are up to date in relation to crime victims, that you're not limiting the scope just to domestic violence or abuse. Any crime victim does have these protections. And there is a required notice that you must give employees upon hire about their rights under this law. The Labor Commissioner's Office has not updated this for 2021 yet. We are keeping an eye on it. So continue to give the prior notice. And once that notice is up to date, it will be on our website that anybody can access. And I'm sure we'll write a blog article or a news article about it as well. Okay, friendly reminder about paid sick leave. If we go on the Wayback Machine to 2015, and remember when the state of California decided to implement mandatory paid sick leave Following that, I think about 17 to 20 jurisdictions created their own paid sick leave. So Monterey County hasn't jumped on that bandwagon yet, but if you have folks who work for you but work in other jurisdictions like the Bay Area or something, you're going to have to pay attention. But the California paid sick leave does require employers to provide paid sick leave for all employees. It's completely up to the employee as to the reason for time off. They don't even need to tell you. They just need to say, I was sick. They don't even need to give you advance notice. And you can't retaliate, discipline, require doctor's notes or anything when an employee takes time off and they're using their mandatory paid sick leave that you're requiring under state law. Local paid sick leave ordinances have similar language, but this particular update is specifically about that California paid sick leave, that 24 hours that you have to provide each year, either as a lump sum or through accrual. Okay, leaves of absence. So if you have 5 or more employees, get ready for CFRA. Make sure you have a policy in your handbook that is mandatory as part of being a covered employer under CFRA, as well as having the CFRA poster. And make sure you have California compliant forms, notice of rights, designation notice, and most importantly, the medical certification. Federal FMLA has all these forms, but sometimes they sneak in a little question like, give us the diagnosis of your health condition. We cannot ask that in California. So make sure you're using California compliant forms. If you have 50 or more employees, make sure your CFRA and FMLA policies are up to date. You may have to separate them out because there's slightly different requirements now. So make sure your CFRA policy is up to date with those changes, even if you have 50 or more employees. Make sure your policies are up to date. Make sure it's clear that you're not going to retaliate against people if they take paid sick leave. Update your crime victims policy. Make sure you've got revised notices and brochures, especially that paid family leave brochure that you must give upon hire and when somebody takes time off. Your CFRA notices and that crime victims notice. As soon as it's available, we will make sure everybody is aware of that. Okay, let's talk about money. Money is way more interesting than CFRA, right? I guess not when you're paying it though. It's more fun when you're receiving it. But let's talk about AB5 real quick. Way back when, again, before COVID, we had this dynamics case that the California court decided that we should follow this ABC test to determine whether somebody's an independent contractor. Because California law presumes that everybody who provides services for you is an employee. However, if you clearly meet this ABC test, this person could be an independent contractor. So you have to meet all 3 parts of this test: free from control, performs work outside your regular business, and the individual is customarily engaged in that work that they're conducting for you. The problem with AB5 is that there are 30 or 40 different exceptions that sometimes there was no real rhyme or reason to. It was very counterintuitive, I guess is a good way to say it. Good lobbying efforts, but it got confusing for folks because even if you met at one of these many exceptions, you still had to follow the old test to determine whether somebody was an independent contractor. So you didn't get out of it right there. So main caution is if you're hiring independent contractors in California, make sure you are 100% sure that they actually are an independent contractor. If you're confused, if you think there's a gray area, remember the law is going to presume that the person is an employee unless they clearly meet this test or one of the exemptions and meet the Borrello test. So make sure you're really clearly analyzing. The biggest place people get in trouble is you have somebody who's worked for you for a while and then they decide they want to retire, but still, dabble with you and help you out every once in a while doing some of the work they did before. That's still an employee. That will never be an independent contractor. Okay. There are a couple other expansions and clarifications, some professional services and business to business exemptions. The scary part that AB 2257 did was district attorneys now have the ability to file claims against employers. It used to just be the state. Now it's localized. So there's more people looking into it. So if you're one of those places that hires a lot of independent contractors and you're not sure whether you're right, you might want to talk to somebody about that. And by somebody, I mean legal counsel in a privileged conversation. So we talked about, even if you don't meet that ABC test or an exemption, you still have to do that weighted test that we used to do a couple of years ago. And it is very expensive, because if you classify somebody as an independent contractor and you're wrong, you haven't been tracking their meal and rest periods, you haven't been tracking their wage statements, you haven't provided paid sick leave, all those things, tax liability. Every agency wants your money. So you do want to be right about this. Little note about the gig economy. Prop 22 was that proposition, Uber and Lyft, that they wanted to have sort of a whole new category of worker. And it passed. California voters said yes, because Uber and Lyft said, we will leave California if this doesn't pass. And we like our Uber and Lyft. So what this did is it created a whole new category of worker. It's not really an employee. It's not really an independent contractor. It's this unique worker. Uber and Lyft have committed to providing healthcare contributions, accident insurance, and a minimum earning guarantee. So it should be interesting how that plays out over time, and if more states will have something similar. Okay, minimum wage increases. So every year until 2023, California's minimum wage is going to go up by $1. So on January 1, if you have 25 or fewer employees, that minimum wage went up to $13 an hour. If you have 26 or more employees, it went to $14 an hour. It's going to go up $1 January 1 next year, and then everybody's going to be at $15 an hour in 2023. The important point to make about this is if you have minimum wage workers and you're right on that cusp, you got 25 employees. The minute you hire that 26th employee, that day, everybody's wages need to go up. There's no grace period until the next payroll period. So pay attention to that in the event that you have minimum wage workers and you're right on that cusp. The other impact that minimum wage has is that California's minimum salary for exempt employees is directly tied to our minimum wage. So if you have 25 or fewer employees, you've got to calculate the minimum salary as 2 times the minimum wage based on 2,080 hours. The state of California assumes that 2,080 is a full-time worker or exempt worker. So if minimum wage is going up $1 every year, that calculation is going to go up every year. So if you have exempt employees, administrative, professional, executive, folks who, exercise independent discretion and judgment, maybe have a license to practice law, different ways they can be exempt based on the job duties they perform. They are not going to be exempt from overtime and meal and rest break requirements unless they also meet this minimum salary. So, easy example, you hire a licensed attorney to work 10 hours a week and you want to pay them $30,000 a year. That is not an exempt employee. They have to be earning at least $54,080 or $58,240, depending on how many employees you have, in order to meet an exemption. They can always be non-exempt and you can pay them an hourly rate, perfectly fine, but they do have to meet the duties and the salary, and that will go up each year. So just like paid sick leave, but even more prolific, local jurisdictions throughout the state of California have decided that $15 minimum wage goal for 2023 should be met sooner. And so throughout the state, we have about 30 odd minimum wages that are higher than what the state of California requires. This has had a big impact on folks, especially as everybody went remote. Because if you were in a jurisdiction that was state of California minimum wage, and then you had an employee, say, starting to work from home in Petaluma rules now apply to that employee, not where you're located. So we do have a form on our website. It's under HR forms and anybody can access it with the minimum wages around the state. So on January 1, a lot of minimum wages went up. July 1, a significant number of jurisdictions also go up on July 1. So make sure you're aware of where your employees are traveling around, where they're spending time as they work. In addition, if they're working from home or remotely, in a jurisdiction that is a higher minimum wage, make sure you're following that. These minimum wages will not impact the minimum salary for your exempt employees, though. That minimum salary is solely based on the state minimum wage. A little bit of good news. Standard mileage reimbursement rate for the IRS went down 1.5 cents. So in California, our Labor Code 2802 requires employers to reimburse employees for any expense they incur due to work. So if I'm driving my car because of work, I need to get reimbursed for that mileage. Our labor commissioner presumes that the IRS rate is the reasonable rate because it contemplates wear and tear, the cost of the car, gas, all those things. So most employers just use the IRS rate because that's what the labor commissioner presumes is reasonable. You can pick a lower rate, but then you have to prove that it's reasonable. But it's 56 cents per mile for 2021. All right. So check your county and city minimum wage laws. If you have folks that drive for you and they spend more than 2 hours in a jurisdiction with a higher minimum wage, you're going to have a higher minimum wage for that time. So make sure you're aware of all of those. You may have to make some increases. If your exempt employees are getting close to that not being on the minimum salary, you may want to consider making them non-exempt because that minimum salary is going up a lot each year. So make sure your exempt folks are meeting that test and make sure your minimum wage poster is up to date. There's a new minimum wage poster for the state of California for 2021. And all local jurisdictions who have a higher minimum wage also have a poster. All right. Hello, Astrid. We're going to talk about COVID for a little bit. We got any questions we want to hammer out before you take over?
Just one for clarification, going back to the CFRA,
Sure.
If an employer didn't designate, and this was somebody who was previously on a leave and they didn't designate because I guess they didn't know, or you know, what would your advice be? What should we recommend they do now?
Well, I mean, first and foremost, legal counsel, but on the best practices end, the thing to think about is what the law says is if you fail to, you can retroactively designate if it doesn't harm the employee. And nobody really knows what that means. I mean, that's been in our regulation for a long time, and it's unclear what that means. However, I think the thing to think about is if you go back and designate for that employee, will it help them? Did they not have their health benefits and you could have reinstated their health benefits? Are there ways that it will be beneficial to the employee to go back and designate? Or will it harm them because it means they won't be eligible for it moving forward? So like anything, always look to what's best for the employees. And if in doubt, contact legal counsel to make sure that you haven't exposed yourself to any liability inadvertently, and then make the best decision based on your risk.
Great, thank you. All right, well, we'll give you some time to get some water and rest your voice there. I'll take over from here and talk about COVID. Good morning, everyone. We'll talk about COVID-19. We're still talking about this. And like Jessica said, I believe we're going to be talking about it for quite some time now. So here are some new information that it's going to be required of employers as we move forward. We'll start with SB 1159. You may have heard of the workers' comp presumption. This is not entirely new, but there's been some updates to it. This is the law that went into effect last year. Back in September, it retroactive to July 6th and applies to all workers in California that said if you contracted, that you're presumed to have contracted workers COVID-19 at work if certain things happen, if you feel that you had to do an analysis of this COVID-19 infection that you got. So the update right now is police officers, firefighters, and healthcare workers, including anyone who supports that staff, such as janitors, who are in contact with COVID-19 patients, are eligible for workers' comp benefits if they get infected while on the job. All others, so if you're not in those industries, you're presumed to be eligible for workers' comp if there is an outbreak. And so there's an actual definition of an outbreak under 1159. If you're a smaller employer from 5 to 100 employees, you are considered an outbreak if 4 or more infected employees at the same location within 14 days. If you're a larger employer, then it's at least 4% of employees at the same location being infected within that 14 days. Or if a health official designates you as being closed and they determine that it's an outbreak. So what this means is you want to make sure you assign someone to track this information. It's going to be important that you have some sort of officer or someone in charge of keeping track of these outbreaks. The rule for first responders and healthcare workers, that rule is permanent. It's not going away unless there's new legislation. For all other workers and other industries, this is going to be effective through January 1st, 2023. Employees do not have to prove they were infected on the job to get benefits. It's the burden is on the employer to prove that the worker didn't get the virus while on the job in order to deny that workers' comp coverage. This also adds that you have to report to your workers' comp carrier within 3 business days of COVID-19 positive case in your work site. How do I know when to report this to my claim administrator? Well, it is when you knew or should have known, reasonably should have known, that an employee tested positive for COVID-19. And this reporting requirement to report to your workers' comp carrier is regardless of whether or not it's work related. So you have 3 business days to report to your workers' comp carrier. And if you haven't reached out to your workers' comp carrier, do that now. They probably already have everything that you need in order to report these. And again, this is whether it's work related or not, you have to report this within 3 business days. The labor commissioner fines are very high, as you can see, up to $10,000 for non-compliance. So make sure you reach out to your workers' comp carrier. Our workers' comp carrier has automatic screen that comes up when you log on to their website, and it comes up and it says, is this a COVID-19 case that you're reporting? So get familiar with your reporting structure for your carrier. So we have this presumption, whether it's work-related, whether there's an outbreak or not. But even if it doesn't meet that definition of an outbreak, there is still this, could it be work-related case that you need to investigate. So your responsibility as an employer is to determine whether this is COVID infection was at work or not. And how do you do that? It's difficult. Well, you're going to ask the employee how do they think they contracted COVID-19? Do you know how? And talk about that. If they're telling you, look, there's no way it could be anywhere else but work because I go from here, home, I order out, I don't go out at all, I order takeout in, and I limit my exposure to everyone. So the only way I could have gotten it is at work. You need to take that information into consideration. Of course, we're going to respect privacy and not go into the weeds of what their daily activities are, but you are going to try to come up with some questions about how they may have been infected. And you're going to also review their work environment. Are they coming in and sitting in an office all alone? Are they out and exposed to clients and customers and other employees? Are they working pretty close to other employees that maybe have also been determined to be positive or maybe have been exposed to someone who tested positive? So use all this evidence to determine whether it was contracted at work or not. Here are some other cases that you can look at. If it's likely work-related, if several cases are coming up, if they contracted it shortly after someone, maybe you had a customer who said that they were tested positive and they had been in your work environment, and maybe their job duties includes the frequently exposing to the general public. So these are things that you're going to use. Again, it's got to be an analysis on a case-by-case basis. If you're looking at a case and you're seeing that this employee is out traveling and they're maybe frequenting lots of public venues and they're going to parties and they're telling you about this and they're telling you they don't care about masks and they're not wearing them, then it's most likely not work related. And you can use this information to make that determination. All right, so that's SB 1159. Now we have AB 685, which is the COVID-19 notification law. And this says that you as an employer have to notify your workers of any possible exposure within 1 day. So companies have to tell their employees if they've been exposed to an individual who either tested positive, or maybe that individual has been ordered to isolate, or unfortunately has passed away. If they've been exposed to someone like that, you need to tell them in writing within that 1 day. In that written notification, you need to include benefits such as anything they might be eligible for, such as this new California supplemental paid sick leave, which we'll talk about. Do they have California paid sick leave, workers' comp benefits, any FFCRA? You're going to talk about what benefits they are owed to them or that they're eligible for. You need to include an anti-discrimination and retaliation provision in that written notification. And then you're going to tell them what you as a company are doing to disinfect and to follow safety protocols to avoid future exposure. This written notification can be sent via email or text. It's going to be your usual method of communication. And again, you have to do that within 1 business day. The notice has to be in the language that they can understand. So if the majority of your employee speak a different language other than English, then you have to get that notification translated to that language. Best practice is create a template notice of use. We have a notification template for you to use on our website. If you go to employers.org and visit HR Answers, and there's a COVID-19 resource page that Jessica talked about. You could do that right now on your cell phone, employers.org, and then go over there. We have a template ready for you to use. So this is something that you can use as well as other request forms that we have. Keep all these copies of notices for at least 3 years because that's the requirement right now. It may be even longer than that, but right now keep them for the minimum of 3 years. So in addition to that, you also need to notify your public health official of an outbreak within 48 hours. We call it the 3-2-1. You have that 3 days if you have an outbreak to report to your, or if you have a COVID-19 positive case to report to your workers' comp carrier. You have this one, which is 2 days to report to a local health official if you have an outbreak, and then the one if you need to tell your employees. So we'll review that in a minute. But employers must report an outbreak to local public health officials within 48 hours. That definition of an outbreak under AB 685 is different than the definition, of course, they just want to confuse us, than the one under SB 1159. So make sure you're aware of that. We'll talk about what this definition is in a minute. Just a side note here, Cal-OSHA can shut down a work site without providing advance notice if they feel there is an imminent hazard of COVID-19. So under AB 685, the definition of an outbreak is 3 or more COVID-19 cases among workers at the same work site in a 14-day period. So again, this is where it's going to be very useful and effective to have an officer who's someone who is in charge of tracking these cases. A COVID-19 case, this is not an exposure. This has to be a true COVID-19 case. Someone who's actually tested positive with a viral test, is diagnosed by a licensed healthcare provider, is ordered to isolate by a public health official, or unfortunately dies due to COVID. So once this threshold is satisfied, the employer has 48 hours to report if you get those 3 in a 14-day period. Okay, so that's AB 685. Now let's move over to Cal-OSHA, because although this was effective November 30th, a lot of employers are still right now in almost April trying to scramble and getting the stuff in order. So we wanted to make sure we highlighted this. The Cal-OSHA requirements for COVID-19 covers all employers, except if you have all remote workers who do not see clients or other employees. So if this isn't you, if you're all having contact with employees and they're coming into your office or location or seeing clients, this is going to apply to you. And the exclusions are only hospitals or skilled nursing facilities. And that's because they have more regulations. They have additional regulations that they must follow. This Cal-OSHA emergency regulation has 3 components: a COVID-19 prevention plan, a COVID-19 prevention items that you must follow and implement in your work site, and it has testing obligations. It's been challenged many times already. Nothing has come through yet as far as a determination. So right now, this is still the law of the land that we must all follow. The new obligation is to implement and maintain a written COVID-19 prevention plan, and it has 11 separate requirements. The good thing is Cal-OSHA did provide a template for us to use. You can find that on our website under employers.org in their COVID resource page, and download that template and make it your own. It can be part of your IIPP, which again, the IIPP is also required by Cal-OSHA, or it can be a separate document. So include it on there or just keep it apart because it's a living, breathing thing that might be changing. The regulations go beyond the prior guidance. Back in the summer of 2020, they told us to have a site safety plan, which you should also have a site safety plan. But this COVID-19 prevention plan is more detailed, and it has these 11 separate requirements. So you can take your site safety plan and just amend this COVID-19 prevention plan if you'd like. Okay, so along with this, our Cal-OSHA says we have to have preventative measures. So you have to have physical distancing of at least 6 feet unless separation is not possible, or it involves momentary exposures during movement, such as passing someone. Requirements for employers to wear face coverings when indoors or outdoors and within 6 feet. The exceptions are going to be if you're alone in an office, in a room, you can take your mask off. If you're eating or drinking and you're at least 6 feet away from other people, you can take your mask off. And for, of course, reasonable accommodations. The use of physical barriers, optimized ventilation, disinfecting, all need to be considered. Provision of hand washing facilities and personal protective equipment. The PPE, meaning masks, at the very minimum, you should at least be supplying that for your employees. They're welcome to bring their own, but if they do not have one or do not want to use one, you as an employer have to provide that. Exposed employees must be excluded from the work site. We get this question into our hotline quite a bit, where people are saying, my employee tested negative, can they return? And the answer is no. Even if they received a negative test result, they still need to wait the minimum amount of time if they have been exposed to someone with COVID-19. So depending on whether they have symptoms or not, that amount is going to vary. And also California's timeline varies from the CDC. So you want to make sure that you're following Cal-OSHA's guidance on that. Cal-OSHA also said you have to provide testing for your employees at no cost and during work hours. And this is true if there is an outbreak. And remember, the outbreak is defined as 3 or more in a 14-day period. It's going to end when there's no new cases. And then it will increase to twice a week if there's a major outbreak, defined as 20 or more cases. And I hope that's never you in a 30-day period. And that's also going to end when there's no new cases in that 14-day period. So remember, there is that COVID-19 testing. There shouldn't be a cost to the employee because right now everything is free. But if there is a cost to them, then you as the employer have to pay for that. And this is an offer. I mean, the employee can say, I'm just going to go on my own and get it. There's not a requirement that you actually physically bring someone into your workplace to do this testing. It's just an offer to pay and make sure you give them the time to go. All right, so we're moving on from the requirements for COVID-19. We're going to talk about the vaccine because this is becoming more and more of a hot topic as it is available to your employees. And the number one question we get is, can we require it? And generally, yes, employers can require employees to be vaccinated as long as it's job related and consistent with business necessity. And the employer, of course, needs to make reasonable accommodations for disabilities and medical conditions and sincerely held religious beliefs. So you as a leadership team must do an analysis of this. Are we going to make it mandatory or not? Does it make sense for our business? Is it job related? Are we going to leave it optional? Does it work for morale for us to make it mandatory versus you may get the same result in the end. So you might want to look at that and see what works best for your industry, for your business, for your employee base. There are some sample forms that we have on our website. Again, we're making it very easy and making this information accessible to all employers. If you go under that resource page on our website, we have a template for vaccines, whether you want to do it mandatory or whether it will be optional for your employees to receive it. The vaccine information is there. The template is there. You can use it and make it your own. What is the state of California saying about vaccines? The Department of Fair Employment and Housing is that state agency that has ruled out some guidance. And this is hot off the presses. March 4th, they came out with the guidance. And they said, yes, you can require, but you must provide reasonable accommodations, again, for those disabilities and sincerely held religious beliefs. They went into a little bit of detail on this. And they said accommodation could include and look like job restructuring, reassignment, or modification of work practices. So you do have to make this analysis and say, oh, well, we just can't do it. Your job it requires you to be here. Well, they want you to go a step further and do this interactive process where you're looking at all these things and can we restructure the job? Can we modify work practices? Employers administering the vaccine. So if you're the one that says we're going to have a drive and everyone needs to come in, you may ask medical information such as pre-vaccination screening. Again, so long as it's job related and consistent with business necessity. If you're having a third party that's administering, or you're just telling someone go get it done, and we are going to need proof before you can return to work, you can require that proof, but you want to make sure you tell them that they need to omit any private medical information. So all we need to know as an employer is that you received the vaccine, but I don't need to know anything else in addition. So if there's more than that on that paperwork they're going to give you, instruct the employee to omit that information. Okay, so now we're talking about, this is hot off the presses again. This is effective yesterday. The California 2021 supplemental paid sick leave kind of took employers by surprise. This is something that went into effect last year in 2020, but back then it only applied to large employers over 500 employees. Well, this new law applies to employers with more than 25 employees. So if you're sitting at 26 or more, or you're right at the cusp, this is going to apply to you. This is a law that is retroactively goes back to January 1. It's going to stay in effect through September 30th. You're obligated to comply as of yesterday, March 29th. This is going to provide an additional 80 hours of leave time. If employee already exhausted their FFCRA from 2020, for example, you're going to provide them an additional 80 hours of leave time. This is a separate section and the labor code outlines similar requirements if you're an employer in the home service, in-home service, supportive services. This is going to be not completely applied to you. A lot of it will apply, but there's a little bit additional guidance for you. So the best thing to do is give us a call if you're one of those employers. The California Supplemental Paid Sick Leave covers employees who are unable to work or telework even due to needing to care for yourself due to COVID. Maybe you're subject to a quarantine or isolation related to COVID-19, or you've been advised by a healthcare provider to quarantine, or you're experiencing symptoms and you're seeking a medical diagnosis, or maybe you're caring for a family member and that covered employee has to be there for them because that family member is subject to a quarantine or isolation order, has been advised, or they're caring for a child whose school or place of care is closed or unavailable due to COVID. It also is going to include vaccine-related absences. So the covered employee is attending a vaccine appointment and cannot telework due to a vaccine-related symptom. Maybe they're getting the vaccine, or maybe they are having some side effects due to the vaccine. And again, this is going to go retro back to January 1. So make sure you're analyzing everything on a case-by-case. It's very similar to FFCRA, but there are some slight differences. So you want to make sure you analyze this on a case-by-case basis. Your responsibility, your requirement is if you get an oral or written request to retroactively pay them for that appointment they had back in February when they went to get the vaccine, then you have to provide payment no later than the payday for the next full pay period. So again, if you have a retroactive situation going on, make sure, does it meet the requirements? And if it does, and they make that request, you need to retro them back to them. This is going to require a posting. There is that link that we have it. We also have it on our website. It's the very first section that you see there in the COVID-19 resources is regarding this topic. And the poster is there. So click on that. You need to download it. It needs to be placed in a visible area such as a break room or wherever you post your posters. And if your employees do not frequent that location, it needs to be sent to them. If they're a remote worker, it needs to be emailed to them. You can require employees to use supplemental paid sick leave before that Cal-OSHA exclusion pay. Cal-OSHA requires that if it is a work-related COVID-19 case, so that whether they've been exposed or have tested positive for COVID-19 and it's work-related, an employer must maintain benefits and pay. Well, you can require the use of this supplemental paid sick leave to cover that. Employers must provide available leave balance in writing. So by the next paycheck, that this law went into effect yesterday, by the next pay period, whenever that is, you need to include on there their available balance for this. So it needs to be put on their pay stub or a separate paper or wage statement that says how much leave time do they have available. If they're a part-time employee, there's some calculations that are going to be different for part-time versus full-time employees. So you're going to want to check our website to look at those details because it is very specific. The Department of Industrial Relations also has a large Q&A on this, and it'll answer a lot of your questions that you may have. But call us in. That's what that hotline is so important and so nice to have, because you can call us in and we'll review your situation with you and let you know how to best move forward with your situation. You can't require medical certification as a condition of payment. So if they're saying they had a vaccine back in February, you can't say, I need to see proof before you pay them. It matches the FFCRA's daily cap. There is a cap both per day, and you pay attention to that. Sometimes if we've already paid FFCRA, maybe you used FFCRA to pay the first quarter, January 1 through March, we'll look at that next. Because you could maybe get a credit for that. So let's talk a little bit about that FFCRA, because that continues. As you know, that was something that went into effect in April of last year. And then they said it was mandatory for employers to continue that through December 31st. That was a requirement. But then January 1st, that tax credit was extended. You could continue to participate on a voluntary basis. So through September 30th, you can still pay that emergency paid sick leave or family medical leave and still apply for that tax credit. Know that in April 1, so coming up on Thursday, the FFCRA changes slightly to include more reasons for taking leave. So some more COVID-19 diagnosis following exposure, and then also it's going to include vaccine-related information. So make sure you look at that because sometimes the FFCRA and the supplemental paid sick leave align, and other times it does not. So again, call us in, we'll analyze it with you and go through on a case by case. So some of the things to include about the FFCRA, that includes an anti-discrimination provision. You have to apply that policy uniformly. You can't say, I'm going to give it to you, but not to you. It needs to be uniformly applied. And California employers, again, if you're subject to that supplemental paid sick leave, it's a good idea to now designate the FFCRA. Maybe you weren't doing it. Well, probably a good idea to do it now because you're going to get a tax credit. That federal FFCRA provides a tax credit and you get your money back, where the California supplemental paid sick leave, you do not. You have to pay that out of your pocket and you do not get reimbursed. But with the FFCRA, you do. So some takeaways: reporting requirements, going back to the COVID information with workers' comp. Make sure that you report to your workers' comp carrier any COVID-19 positive case within 3 days. To the agency, any outbreak to your local health department within 2 days. There's your 3, 2, 1. And then to your employees, prepare and distribute written notice of COVID-19 within 1 day to your employees. You're going to investigate whether these are work-related COVID-19 cases or not, because workers' comp can still apply even if there is no outbreak. You're going to develop your COVID-19 prevention plan. It's very important that you do that. Let's see, my mouse got stuck there. You're going to prepare and offer. How are we going to do testing? Are we just going to tell them to go to the county website to find a COVID-19 test? Are we going to have a clinic or workers' comp clinic? Maybe they provide COVID-19 testing. Have a plan in place for that. And then regarding this new leave, the supplemental paid sick leave, remember that this is in addition to FFCRA, but it can also offset, or you can also get some credit. It's going to be an analysis on a case-by-case basis. You're going to analyze as a leadership team whether the vaccine, you're going to make it mandatory. Are you going to make it an obligation to get it, or are you going to leave it on an optional basis? Remember, we have some templates that CEA has offered and made available to you if you would like to use those. I'm going to pause there for a minute just to see if there's any questions, or should I keep going? Jessica, regarding our other laws, I'm not sure we're doing on time, if I should just keep going.
Pretty good on time, and I am lurking here. You've been very thorough because the Q&A box has been quiet, but I know a big question that we get on the hotlines is the tax credit. So there's FFCRA, which is now the AREA or something, right? That federal law, but now we have this mandatory supplemental paid sick leave through the state if we have more than 25 employees. do we get paid back for that supplemental paid sick leave through the state?
Yeah, so there is no payment, no credit to you through the state, but there is through the Families First coronavirus, or that new, well, like you said, Biden just signed that new one. So you may be able to, you know, offset that or get credit and apply that. They kind of work together, but you have to analyze to see if the reasons are right. So as an example, if you had an employee who was out in February due to a vaccine, that was not covered by the FFCRA. That's not going to be effective until April 1st. So they kind of missed that. So you'd have to pay and cover them through the California Supplemental Paid Sick Leave because the FFCRA didn't cover. And so you wouldn't be eligible for that credit. But if you have a future employee that misses work due to a vaccine after April 1st, you could say, I'm going to pay the California Supplemental Paid Sick Leave and at the same time use that FFCRA and apply for that credit.
So I hear you saying is that each time we get a question about supplemental paid sick leave, we should probably look at a case-by-case basis.
That's right. Yeah, because you'll have to look to see whether or not it's going to meet the requirements of both, whether they align or not. And when they do not align, you won't be able to do that. When they align, great. And that's why you should definitely explore that. Now going back to whether I didn't assign FFCRA back in January, maybe I should have, we don't know really. I don't know, Jessica, do you want to speak to that? I don't know if we can really say, I think what we said is you should try because you may get that tax credit through the federal. I don't know if they're going to allow that retro back so long since you didn't choose to do it back then. But worst case
I would
scenario,
check with your bookkeeper or accountant, and to your point, Astrid, file that Form 941 with the IRS to make that deduction from your payroll tax. And if it gets rejected, just be prepared for that rejection, but also talk to your accountant or bookkeeper on how that's going to work.
That's right.
All right.
Yeah, lots of moving parts, and just give us a call and we can help you. Okay,
Carry
so
on.
moving on. All right, moving on to some diversity and equity and inclusion new laws for 2021. Jessica mentioned this at the beginning of the presentation. We have SB 973, the pay data reporting. So an employer who meet the following requirements, you have to submit that annual information on pay data by race, ethnicity, and sex to the Department of Fair Employment Housing. This is California by tomorrow, March 31st, and then every year thereafter. And this is going to be the criteria you must meet. If you're an employer with 100 or more employees, and you're an employer who is required to file under the EEO-1 under federal law, then this is you. You must report this information by tomorrow. The link down there to the DFEH is live, and you can go and do that online. So it's pretty user friendly. There's a lot of FAQs on there if you get stuck, or give us a call, but you should be able to get that done by tomorrow. Also, the EEO-1 has just recently, as of this week, put out information, and they are also saying that you need to report that EEO-1 federal annual employer information report. Remember, they kind of had a pause year last year due to COVID, so you need to report 2019 and 2020, and I believe the deadline is in July. So that's also open and ready to go as well. So make sure if this is you that you're meeting both, okay? The one by California by tomorrow, the federal one by July. All right, moving on to AB 979, corporate boards. This is very similar to a law that was in effect a couple of years ago when they said women had to be on the board. Well, this is by the end of 2021, any publicly held domestic or foreign corporation who has a principal office or a headquarters in California, you have to have at least one director from an underrepresented community. By the end of 2022, if you have a corporation with 5 to 8 directors, you have to have a minimum of 2 directors from an underrepresented community. And then if you're a very large corporation with 9 or more, it's going to be 3 directors. The fines are very high. I don't know that there's anyone on that would meet this criteria, but we wanted to make sure we shared it because it is important information nonetheless. Some industry-specific laws aimed at you. I'll go quickly through this one. I don't know if anyone's on that's in this industry, but there is this hospital PPE stockpiles. Employers must maintain specific stockpiles of certain respirators, filters, cartridges, surgical masks, If you provide medical service and a 24-hour inpatient care, this will apply to you. Make sure you look at that labor code section to ensure that you're meeting this criteria. This is a new one that's really important to be aware of. AB 1963 is HR professionals and supervisors are now mandated reporters. You know, mandated reporters was something that our educators fell under, and also maybe some healthcare professionals, but never us in the business world, never HR professionals and never supervisors. Well, now the new law says we are now mandated reporters. And so this is effective January 1. There's a new, for any business that has 5 or more employees, your HR folks and your frontline supervisors who supervise any minor are now going to have to undergo this training and be mandated reporters. Failure to report is a misdemeanor. As you can see, there's some fines and some jail time or both. So important that we comply with this law. You're going to have to train your supervisors. They need to know, what is a mandated reporter? What do I need to do? What's my responsibility? So we want to make sure that you know you can go to the Office of Child Abuse Prevention. There's a website there. I will warn you, the training is about 3 to 4 hours long. There's nothing in the law that says it needs to be that long. So CEA has done their own version and their own training that meets the requirements for this child abuse prevention. And so if you go on our website and go under training, we are offering that coming up in April. So it's $49 to our non-members. If you're a member of CEA, it's free. And so if you employ minors, you want to make sure that you get into this training. It's very important that we train our human resources employees and any adult whose duties require direct contact with or supervision of minors in the performance of their duties in the workplace. There are also some changes to our harassment prevention training. Hopefully you've all done that. You took care of that by the end of 2020, because as you know, our State Department agency requires that any employer with 5 or more employees provide 2 hours of training for supervisors, 1 hour of training for all employees. Training needs to be interactive. The change here is that the policy that you have in place needs to include the Department of Fair Employment and Housing's harassment training link. So there's a link and a training that they provide for free. You don't have to take it. There's no obligation to take their specific training, but you do need to include the link nonetheless on your policy. And then also for minors, just be aware that you can elect to train minors who are between 14 and 17 in the same way you train all your other supervisors and your other employees, or in a different manner, maybe better suited to minors, as long as you provide similar training and includes all the required topics. You also need to know that the minor may be accompanied by a parent or legal guardian if they choose to. You don't have to pay the legal guardian or the parent to attend the training, but you do need to make it available for them. All right, so some recent cases affecting employers that we just to kind of close out and round out our presentation, we wanted you to just be aware of these things that recently have been ruled, and we want to make sure you know about them. One of them is Walmart. You may have heard about this in the news. Walmart and the EEOC agreed to settle a nationwide sex discrimination complaint for $20 million. The agency alleged that Walmart engaged in sex discrimination by using a physical abilities test. They had a lifting requirement that I think was like 60 pounds. And this created a disparate impact on female applicants. What they found was that this job didn't really require you to have to lift that much. And because they made this physical abilities test, it ruled out so many people that could have maybe done a good job on that. So the employer takeaway is to be cautious when you're creating this hiring assessment. If you have those hiring assessment, you may be inadvertently excluding a protected group. So you want to make sure to review that and be prepared to show why you have this requirement. Why do you have this ability test or an exam? Does it really measure what you're trying to accomplish in that job? Is it related to the performance of that job? PricewaterhouseCoopers also got in trouble because they were recruiting in their college campuses only. And so what they found was they would go into these college campuses and recruit from there. And suddenly, college campuses tend to be younger aged people. And so suddenly they had a very young workforce. And so they were accused of refusing to hire older workers by filing these staff positions, almost always through college campuses, and they failed to post entry-level accountant jobs on their website. So they got hit with this is a settlement for $11.625 million. So the takeaway here is assess your recruiting practices and ensure you're not excluding applicants that are in a protected class of course, the protected class here being applicants over 40. IKEA meal and rest break. This is something we should all know already, but IKEA got hit with this recently. They agreed to pay 7.5 to settle a wage and hour discrimination class action lawsuit. Employees alleged that they could only take their meal breaks on campus, on their on-campus cafe or other designated area, but they had to stay on the premises for their rest breaks. And we can't do that. If they can make it to the Starbucks and back in their 10-minute rest break, you need to allow that. So we want to make sure you look at your handbooks, that you look at your policies for meal and rest, and that you're not saying on there that you need to stay on the premises. It hasn't been that way for a very long time. We want to remind you to update your handbooks. They need to be allowed to leave. As good as IKEA's cafe is, you need to allow them to be able to leave for both meal and rest breaks. Another thing I'll mention, because this is very recent, the California Supreme Court just ruled on the topic of meal breaks not to round meal periods. So if you were someone who was rounding meal periods, this has recently been settled and ruled and clarified by the California Supreme Court. And they said the rounding meal periods is inconsistent with California's precise time requirement. So please pay your employees, have them record actual time for their meal periods and do not round. Okay, we want to remind you about the hotline for employers. We've given you a lot of information and we don't want to overwhelm you. So know that this is something that is available to you for you to call in. And again, especially as it relates to the supplemental California paid sick leave, because it's so new, or any other COVID related or pay information, maybe leave of absence, give us a call. We will analyze each situation with you and spread the word, because this is something that's available to you all in the county, and we'd love to help you. Do we have any questions, Jessica, before we continue?
We had one question, which is always a good one, about the pay data reporting through the Department of Fair Employment and Housing. And what does 100 employees mean? And the easiest way to say it is, if you file the EEO-1 report under federal law, you have to file this pay data reporting. But another way to look at it is, if you have 100 employees in the universe, you have to file EEO-1 and pay data reporting. So I think one thing that came up for us, especially in January and February, is a lot of our members were calling saying, what is this EEO-1 report now? Mm-hmm. And realizing that that was something they needed to have been doing. So if you have 100 or more employees, make sure you're aware of both of those requirements. And I think you mentioned it, the EEO-1 deadline has been pushed out to, I think, July. Is that right, Astrid?
July, yeah, 29th.
But the DFEH is not as forgiving. So the golden state is not so golden for employers with 100 or more employees. But yes, thank you all so much for being here, and thank you, Monterey County, for supporting this hotline. It's an amazing resource in addition to everything else that Monterey County does for its employers. So thank you very much. And here are your codes, HRCI and SHRM codes. For those of you listening, HRCI 553664, and your SHRM code is 21Y, N is in Nancy, S is in Sam, U, F is in Frank. So thank you, and back to you, Tara.
Awesome. Thank you, ladies. That was great. Tons of information. It looked like you got some great questions too. So thank you, everybody, for hanging in there with us. Please take 30 seconds to just do that quick survey. It really helps us out, and it could garner you a Starbucks card. So, that can't be all bad. Thank you again. If you have any questions, please give us a call. If you have any webinar needs and there's something on, please go on to CEA or employers.org and check out our webinars. If you need anything, please let us know. Thanks, everybody. Have a great day. Bye-bye.
Bye.